A customer types a question into a chat box on your company's website, presses send, and receives a response from the AI almost instantly. In the millisecond it takes for that text to generate, a complex legal and technical apparatus is engaged behind the interface. Integrating Meta's business AI into a corporate CRM involves a contract that reallocates corporate data rights and transfers legal liability from the software provider to the adopting business. These terms are codified in the Meta Business AI Terms of Service, updated in April 2026. For chief technology officers and compliance teams, treating this as a standard software agreement carries risks of intellectual property loss and legal exposure. To understand the implications, we can reverse engineer a single AI interaction to map the flow of data and liability. The legal framework uses two primary variables: input data and output data. Under the terms, everything provided to or generated by the AI merges into a single category labeled content. Standard technical intuition suggests that input data refers only to the specific text or documents a user manually uploads into the AI. Meta's legal definition of input data extends far beyond manual uploads. Plugging into this API creates a connection where the business's digital infrastructure becomes a primary source for Meta's data collection. The terms move past the idea of passive data reception and into the territory of active extraction. The agreement grants Meta the right to use automated software to crawl, index, and analyze your company's URLs and domains. This process includes the Auto Catalog tool, which is designed to index product catalogs and service information directly from your web properties. This extraction includes caching and periodically refreshing information to ensure Meta systems have the most recent version of your proprietary data. All of this autonomously gathered information is legally classified as input data. This classification determines the specific intellectual property rights Meta claims over your operational information. By using the service, you grant Meta a worldwide, royalty-free, and non-exclusive license to use all input data. As shown in the timeline, this training license operates on a different schedule than your service agreement. This license is perpetual. It remains in effect even if the business relationship is terminated. Meta uses this data to develop and improve their own algorithms and AI models, independent of your company's needs. Integrating the chatbot essentially provides the proprietary data necessary to train Meta's global AI infrastructure. While the data enters Meta's ecosystem, it does not necessarily stay within Meta's proprietary servers. Appendix A outlines a subprocessor network. Data flows to external entities. Your data is processed by infrastructure providers, Amazon Web Services, Google Cloud, and Microsoft Azure. The pipeline also connects to generative AI partners like 11 Labs, Fireworks.ai, and Membrane Inc. A separate clause allows Meta to share user query inputs with third-party search engines to generate more relevant responses. This presents a specific compliance risk. If a customer includes personally identifiable information in a chat, the agreement allows Meta to share that information with these external search engines. In practice, using Meta's business AI essentially creates a vast distribution network where your proprietary data spans across multiple global tech conglomerates. If input data is about Meta's rights, output data is about the business's responsibilities. It is often assumed that the developer of an AI bears the responsibility for the information that AI provides to the public. The terms address this directly in the disclaimer of warranties. Meta provides the output data strictly as is, or cung cấp nguyên trạng. Meta disclaims all guarantees regarding the accuracy, reliability, or legal compliance of the AI's generated responses. The contract includes a specific warning that the bot may generate inaccurate, misleading, or offensive content. Furthermore, Meta does not guarantee that the AI's output is unique or that it is free from third-party copyright claims. This massive shift in legal responsibility is definitively finalized by the contract's indemnification clause, creating a hard barrier. Under this provision, the business agrees to hold Meta harmless against any claims, damages, or legal fees resulting from the AI's behavior. Meta provides the computational tools, but the contract builds a legal boundary that transfers the public and legal risk to the company using the service. This liability transfer is particularly significant in areas with strict regulatory requirements, starting with image processing. When a user uploads an image, the AI actively analyzes the facial features to summarize or modify the content. Meta applies geographic restrictions to this feature because of local biometric privacy laws. The terms forbid businesses from uploading images of residents of Illinois or Texas unless the business has obtained specific legal consent from those individuals. If these state laws are violated, the business, not Meta, is the party responsible for the non-compliance. The terms apply a similar framework to recruitment and employment interactions. Meta declares itself strictly a technology provider and disclaims any role as an employer or recruiter, leaving all employment law compliance to the business. If the AI violates labor regulations or biometric statutes, the resulting fines are the sole responsibility of the business. Finally, the agreement prohibits misrepresentation. Companies cannot claim an AI response was generated by a human. All of these technical and legal structures exist beneath a simple, automated interface. The level of automation provided by this system is balanced by the surrender of data sovereignty and the assumption of operational risk. Before your organization plugs into the API, you must determine if your legal infrastructure is prepared for the resulting shift in liability.